Good evening, your lords and ladyship. The appellant today, Mr. Barker, contracted COVID-19 after attending the theatre of...
Before you commence,
Yes, sorry.
could I just ask, what is the situation in relation to the submission
Mr. Barker,
of the bundles?
contracted COVID-19 in what way after attending the theatre of...
There was a deadline set for the submission of the bundles.
Yes.
I believe the appellant had filed theirs in time,
Yes.
and the respondent filed theirs with bundles. Is an application by the respondents. There was a deadline set for relief from sanctions for filing late. I believe the appellant had filed theirs in time, and the respondent filed theirs with bundles. Is an application by the respondents.
It is submitted that the bundle was received late due to programming errors. It was the first time the responding counsel had been using Adobe, and unfortunately, we're not aware that the file sizes would be triple what they typically are. And upon submission through email, it was discovered, unfortunately too late. And while attempting to compress files, attempting to transmit files to Word, and there were a series of issues, and it was not favorable, unfortunately. We apologize greatly. While attempting to compress files, it did not transmit files to
And
Word.
it was submitted without sight of the other sides, skeleton and authorities.
We apologize greatly.
When you submitted your skeleton and authorities, did you have sight of the other side, skeleton and authorities? The other sides.
Did we have them prior to submitting ours?
Yes, you're meant to have simultaneous submissions. So, did you have any opportunity of seeing the appellant's skeleton and authorities before you submitted yours?
No, Your
Yes,
Honor,
you're
we
meant to have
did not look
simultaneous
on
submissions.
the appellant's documents. We were
Did you have any
attempting
opportunity of
to
seeing
quickly and swiftly send the documents over to our lordships, and did not have the time to look through the documents.
So it's just a pure technical.
Attempting to quickly and swiftly send the documents over.
Thank you.
Thank you, Your Lordship. So the appellant today, Mr. Barker, contracted COVID-19 after attending the theatre belonging to the respondent, Ms. McIntyre. The respondent forewent taking any precautions with regards to protecting her audience from the risk of COVID-19, and subsequently the appellant is now pursuing a claim in name of the respondent, Ms. McIntyre. Would your lords and ladyship care for more detailed information on the facts of this case?
No, thank you. We're familiar with the facts. Could you please address the law?
Yes. So first and foremost, it must be noted that due to the timing of when Mr. Barker attended the theatre, the nation was following the government's autumn-winter roadmap, and thus governmentally mandated precautions were extremely minimal, especially in theatres, and therefore Ms. McIntyre was not in breach of any legislation. However, this council does submit that she was under a tortious obligation to reasonably protect her audience from the virus. And therefore, if it pleases your lords and ladyship, I will now begin my first submission. However, this council does submit that so for this submission, your lords and ladyships may direct your attention to the case of Caparo Industries, PLC and Dickman, in the second volume of the Appellate Court Law Reports in 1990 on page 605. Firstly, would your lords and ladyships allow for dispensing of formal case citations?
Yes.
Thank you. This case can be found on pages 7 to 66 of the appellant bundle, with the relevant provisions highlighted on pages 20 and 21. Would your lords and ladyships care for a summary of the facts of this case?
Please.
So the claim in this case was for negligent misstatement, and an accountancy firm appealed against a decision at the Court of Appeal in which it was decided that accountants owed a duty of care to current and historic shareholders. Caparo Industries had bought shares, current and previous shareholders when producing audit reports. Caparo Industries had bought shares in a company that was described in such an audit report. it transpired that the information in this report was incorrect, and subsequently, Caparo suffered a substantial loss. At the House of Lords, the Court of Appeal decision was reversed, and it was found that that accountants only owed a duty to the reasonable governance of said shares and not directly to the shareholders themselves. The most important part of this judgment for this submission today is, in reaching this conclusion, the tripartite test for a duty of care was established, namely that if a defendant owes a duty of care towards a claimant if A, harm was reasonably foreseeable, B, there was proximity between claimant and defendant, and C, it was fair, just and reasonable to pursue a claim.
Can you take us to the section of the judgment which deals with that, please?
Yes, that will be on section H on page 617 of the judgment. So it spans page 20 and 21 of the appellant bundle. Thank you. So to apply this tripartite test to our case today, the second two criteria this council submits are easily satisfied. For there was proximity easily established between Ms. McIntyre and Mr. Barker through both a notion of time and space and also through a relationship of knowledge. Secondly, as Ms. McIntyre was not acting on behalf of a public body, the presumption that it would be fair, just and reasonable to sue stands. Therefore, the question becomes, was harm reasonably foreseeable? This council submits that, yes, it was. At the time, statistics were being published in daily news reports that 1 in 85 individuals were contracting COVID. Statistically, this means that in a theatre of 2,200 people or above, around 26 individuals would go on to contract COVID-19. This number will only be inflated due to the nature of such large theatres. They are inside and crowded with very poor air ventilation. So objectively and statistically, yes, harm was reasonably foreseeable. The same Ms. McIntyre was not aware of these specific statistics, even though they were being published in daily news reports. Due to such high infection rates, in autumn of 2021, COVID-19 was still very much at the heart of everyday national affairs, and the reasonable person would have been well aware of the threat of COVID in their day-to-day life, and this includes Mrs. McIntyre. Additionally, being the manager of a theatre in London, she will have been aware that other theatres in the surrounding area were enforcing strict precautions to protect against the virus. Theatres like the ones that Mr. Barker had been attending in the previous few weeks. The decision to impose such precautions against COVID for these theatres will have come at a great financial burden to these theatres, especially being small venues. Therefore, the decision to do such would have been closely considered and certainly not taken lightly. So because of these three things, we believe that harm was in fact reasonably foreseeable, and the tripartite test for arisen from Caparo was satisfied, showing that Ms. McIntyre did owe a duty of care beyond complying with the minimal governmentally mandated restrictions at the time.
So what would you say she should have done? Are you saying that there should have been 5 spaces between every single person? Or at what point would she have discharged her duty?
No, Your Lordship. We believe that relevant provisions from this can actually be taken from the Occupiers Liability Act in 1957, as per my second submission. This is obviously a negligence-based tort, and so statutory information given regarding the scope of a duty of an individual can be very persuasive, especially as the facts of the instant case reflect very closely those of an occupiers liability case. And at section 2.2 in this act, which can be found on page 69 of the appellant bundle. We can see here that an occupier must only take precautions as to ensure the reasonable protection of a legal visitor on their land. There is no need here for complete or perfect protection for the audience from the risk of COVID. So social distancing, as your lordship has stipulated, was not necessary in ensuring reasonable protection. Precautions such as imposing a mask mandate or demanding a proof of a negative lateral flow test or of a proof of two vaccinations on the door would have been sufficient to substantially reduce the risk of COVID-19 and provide reasonable protection for the audience. That will also be very relevant when discussing the financial impact that imposing such precautions would have on the theatre. Does that answer your question, your lordship?
So can you explain how is it that the government doesn't consider that these steps are reasonable or required, and you say that there arises a private law duty that goes beyond regulation? Can you cite me any authority in any case where the private law has imposed a greater duty than that imposed by statute or regulation?
Well, I think the context of the answer to that question is that this case arose at arguably the height of the COVID-19 pandemic, which presented unprecedented and unique times for which the nation and the law both operated under. Therefore, there will come perhaps strange circumstances such as the one just stipulated to reflect the uniqueness of the circumstance in which the case arises, where private law would supersede government regulations. Additionally, it needs to be noted that government regulations took into account multiple factors that did not simply include the risk of injury between two private individuals. They took into account economic factors, they took into account the future and commercial viability of regulations, whereas tort law deals not with commerce and trading and economics, but with simply the relationship between individuals. And in that way, the difference in the focus of private law to the governmentally mandated restrictions, I think, is highlighted in cases such as this one, where exceptions must be made for the private law to supersede the governmental regulations.
And how is your client not a volunteer? How are they not contributory negligent to this? They could have seen the stipulations, seen the situation, and left, asked their ticket price back. But they remained in, as you say, very new, novel situation. Isn't that their responsibility?
I think, yes, obviously, there was an element of contributory negligence, but the courts must also consider the fact that the tickets were extremely expensive. They were £150 per ticket, which was non-refundable, as stipulated in the facts. This would have been a great inducement to stay, as well as the fact that it's not stated specifically in the facts where they live, but they live far away enough where they had to take public transport to reach the theatre. All of these things clearly act as an inducement for the appellant to stay at the theatre. Additionally, while he did stay, he did everything within his power to protect himself from the virus, i.e. from wearing a mask. And so in that way, while obviously contributory negligence will be considered by the respondents, I think this argument will be seriously negated by these inducing factors. And also, contributory negligence is not a complete defence. Contributory negligence can still stand and liability can still be found in Miss McIntyre for her negligent omission. So if it pleases your Lords and Ladyships, may I now begin my third submission?
Yes.
So this submission takes from the case of Tomlinson and Congleton, as found on pages 109 to 168 of the appellant bundle, with the relevant highlighted provisions on page 146. Would your lords and ladyships care for a summary of this facts case? This case is facts.
Please just take us to the.
So the primary provision arising from this case, as stipulated by Lord Justice Hoffman, was that when assessing what counts as a fulfilled duty, namely what has been such care in the circumstances of the case as is reasonable, one should evaluate a range of factors, namely the size of risk, the seriousness of the risk, the practicability of precautions, and of course the social value of abstaining from protecting against the risk. Lord Hoffman also expanded the relevancy of this provision from 1984 occupiers liability regarding unlawful visitors to cases of lawful visitors. So to apply these factors to our case today, the size of the risk is, as aforementioned, very high. Statistically, at least 26 people in that theatre would go on to contract COVID, and this number would be much higher once taken into consideration the inflation of this number due to the nature of this large theatre, it being in close quarters, people sat right next to one another, being indoors with low ventilation. The seriousness of the risk is also potentially very high. Mr. Barker ended up hospitalized with COVID, which obviously is very serious. However, the potential severity of a case of COVID-19 could be far higher than this. Many people have died from COVID-19. And the virus also affects individuals differently. And Ms. McIntyre knows this, but was also unaware of any vulnerabilities or predispositions in her audience members that may mean the virus may hit them harder than other people. Therefore, in allowing for individuals to potentially contract COVID-19 and then die, the seriousness of the risk is therefore extremely high as well. These two things must obviously be balanced against the practicability of precautions and the social value of not protecting against the risk. Now, regarding the practicability of precautions, obviously it has been stated in the facts of this case, that Ms. McIntyre's reason for not enforcing any precautionary measures was to recover financial losses incurred during the lockdown. Now, obviously, the main precautionary measure, which would cost so much money that, as stated in the facts, the theatre would have to close down, would be social distancing, as this would allow for only around a 50% capacity of the theatre. But as stipulated in the Occupiers Liability Act, Ms. McIntyre did not have to completely protect her audience from the virus. She only had to take the necessary precautions as so that they would be protected reasonably from the virus. There are other ways that she could do this, which are very easy and with minimal to no financial burden to the theatre, such as imposing a mask mandate or demanding proof of negative lateral flows on the door. To not take such easy and accessible precautions should only emphasise liability on the part of Ms. McIntyre with regards to her negligent omission. And finally, to regard the social value. Obviously, if the theatre had to close, yes, this would deprive a community of theatregoers and the local area of a brand new exciting show, which would obviously take in a lot of money and provide a lot of enjoyment for theatre fans. However, as just mentioned, reasonable precautions could have been taken that would not lead to this consequence, that would have minimal to no financial impact on the theatre. Therefore, alternatively, if Ms. McIntyre was so adamant to keep her theatre open with no precautions against COVID and keep the show running, she could have simply delayed the opening of the production, as so many other theatres in the area were doing, until the risk of COVID had been confidently reduced, and there she could open her show with no precautions safely. This would obviously still be a detriment to the local area and to the community of theatre fans, but this detriment would be minimised. Finally, this council acknowledges the implications of finding tortious liability for an individual who is not enforcing what are frankly optional precautions. And that to set this as a precedent would seem awkward and perhaps unreasonable. However, the courts must remember the outreach of the negligent and frankly irresponsible omission of Miss McIntyre. She had assumed care of over 2,000 individuals every night, and it doesn't seem just that the personal preferences of one individual should be allowed to negatively and potentially dangerously impact thousands of people every week, all the while being completely protected from liability under considerations for practical implications of this judgment. Negligence is very malleable and flexible, and as previously stated, this case arose in a time of unprecedented circumstance. And so this council submits that the tort of negligence should be adapted and applied to cater for such unprecedented circumstances, and that perhaps unusual judgments such as these should be allowed to stand.
Can we think this through a little bit further?
Yes.
So if I've understood your submissions correctly, you're saying without recourse to statute or case law, that a duty of care under the Occupiers Liability Act goes beyond government regulation and statute.
Yes.
That it's therefore the duty of an owner of premises to consider wider considerations of safety and need, especially in unique COVID times.
Yes.
That they're not entitled to rely upon what the government say in terms of their regulations. Yeah, that's what you're saying.
That they should follow.
They can't use the government regulations as a shield. They've got to make a determination themselves.
Yes, but also that they can't directly contravene governmental regulations.
Yes.
They're arguing for a duty of care beyond governmental regulations.
But you're asking, in this case, for it to go beyond the government regulations.
Yes. Yes.
So are you inviting this court to recuse itself?
Essentially, yes.
Because if we find in your favour, then won't your client, who I assume is in the court somewhere, be bringing a case against this court? Because we are in a situation where COVID numbers are higher than they've ever been, hospitalizations are higher than they've ever been. We can't say that there's no government regulations, and we're in a room in which there's no social distancing, there's no mandatory mask wearing, and there's no mandatory lateral flow tests. So wouldn't we be in exactly that same situation here and now?
That's an interesting point, Your Lordship, but I think we have to consider that the context of the courtroom today, it can be assumed that most or all people in here have received at least one vaccination, probably two. This was certainly not the case in October 2021. And also that the scale of this room is a tiny.
Well, October 2021, most people had received two vaccinations. We had the booster programme starting in December, didn't we? So what's the difference?
That's true, Your Lordship. However, in this theatre, it's admitted that we need to there should be a separation between the tortious obligations and the obligations under governmental regulations. Regardless of the governmental regulations, Miss McIntyre was knowingly exposing over 2,000 people to potential physical harm.
I get that. Why aren't we doing that now?
Because the pandemic ended almost a year ago, and COVID is not so much of a public threat anymore. Hospitals are equipped to deal with it now. People have received boosters and vaccinations. And yes, a few individuals in here are wearing masks, but that's no longer at the risk that they were a year ago. Therefore, and unless I can aid the court further, that will conclude the submissions on behalf of the legal appellant. Thank you, your Lord and Ladyships.
Good afternoon, your lordships and ladyship. I will now address the second grounds of appeal, namely that the learned judge and court of appeal aid in their determination that causation could not be established in the instant case to ground an action in negligence. My first two submissions will refer to factual causation and my third to legal causation. In my submissions, I will outline the use of the but-for test and how material increase in risk is an alternative test that may also be applied. Furthermore, I will outline how the harm suffered by Mr. Barker was foreseeable and there were no intervening acts that constituted breaking the chain of causation. If it pleases the bench, I will now begin my first submission. If I may draw your attention to the case of Cork and Kirby, which you will find on page 166 of the appellant bundle. A summary of the facts of the case can be provided if you wish. I refer you to a quote by Lord Justice Denning, which you will find highlighted on page 171. But the bench let the quote read aloud.
That's okay, thank you.
Lord Justice Denning outlines that if the harm that has occurred would not have happened but for a particular breach of duty, then that breach is in fact the cause of the harm. The but-for test is established on the balance of probabilities. If it can be shown that there is a 51% probability or more that the harm that Mr. Bishop suffered was as a result of the negligent omissions of Miss McIntyre, then causation is sufficiently established. Mr. Barker did not attend the workplace. He worked entirely from home. He also lived alone. Therefore, there are very few causative factors of infection. In fact, there are only two known potential causative factors of contraction of the virus. The first being due to Miss McIntyre's negligence and attendance at her theatre, and the second as a result of the use of public transport to and from the venue. Mr. Barker is known to have used public transport to attend the theatres in London. However, it is submitted that the possibility that he contracted the virus whilst on public transport is rather low. Transport for London is a local government body responsible for the majority of transport in London, including on buses, rail, and the tube. Transport for London have consistently required the use of face masks on any and all transport that they operate.
Where was he travelling from?
Respectfully, Your Worship, his travel point is unknown, however.
Then what difference does it make? I mean, if he's travelling from Newcastle, then he's not under transport for London, that doesn't mean anything.
Respectfully, Your Worship, it can be assumed that this is the fourth or third venue that he has attended in London, and the likelihood that he used public transport that is operated by London.
Well, I live down here and I travel to London frequently to go to the theatre. So are you saying that the only people who go to theatre in London are Londoners?
Not at all, Your Lordship. However, having if we are assuming that he lives in London, then public transport would be operated by transport.
But there's nothing in the facts which support that, are there?
No, Your Lordship.
Then can we move on?
Yes, Your Lordship. It is known that such safety measures, such as face masks, are likely to reduce the transmission rate of the virus. Given this, it can be said that the probability of contracting COVID-19 is far lower, my apologies, Your Lordship. It can be said that the probability of contracting COVID-19 was higher in the theatre, where there were no masks, no social distancing, than the possibility of there being these same measures implemented on public transport. Furthermore, if such safety measures have been implemented at the theatre, to use the words of Lord Justice Denny, the injury would not have happened just the same. It was in fact this breach of duty and lack of safety precautions which have caused him to contract COVID-19. If it pleases your lordships and ladyships, I will now be getting my second submission. It is submitted that even if this court were to find that the but-for test could not be satisfied, the respondent materially increased the risk of the appellant sustaining injury. If I may draw your attention to the case of Shenkovich, which you'll find on page 174 of the bundle. Would the bench take for a summary?
Thank you.
On page 183 of the bundle, highlighted near the bottom, it was noted by Lord Phillips that a special rule of causation was required given the unusual features of the disease. Again, on page 214, you will find highlighted a passage by Lord Phillips where it is stated that liability fell on anyone who has materially increased the risk of the victim contracting the disease. As previously stated, the lack of social measures taken by the respondent, such as the use of face coverings, limiting capacity to enable social distancing, and the use of hand sanitizer, would have decreased the appellant's risk of contracting COVID-19. Although there is a clear distinction in the specific disease in the case and the current one before the court, it is submitted that the similarities justify that the same principles be applied in this case. Asbestos diseases can be caused by exposure to a single fiber, much like COVID-19, where a single particle can cause the illness. The modification to the general but-for rule in this case was in part due to policy issues with the but-for test, namely that it had the potential of denying claimants justice. Similar issues are likely to arise with negligence claims related to COVID-19. For example, where there are multiple potential causative factors, there is likely to be increase in difficulty in establishing causation. COVID-19 is similar to these cases in that the symptoms are not immediately apparent, leading to further difficulty in establishing causation by the use of the but-for test.
Are you not stretching the asbestos case too far? In as much as with asbestos, you know that there are multiple places in which there may be an amount of asbestos dust. That, however, you can identify a limited number of places where there's potential asbestos dust. And you could also identify that somebody would be there for a sufficient length of time. So though they can't join all the dots, they brought this in to give justice. However, with COVID, it's a public disease. And therefore, in theory, it can be everywhere all the time.
Yes, Your Lordship. And
so it's different, isn't it? So they've come up with something to deal with a particular situation. But wouldn't you be expanding it to a point where it almost became ridiculous because, you know, it's not actually just this theatre, is it? It's going into the shops, it's the delivery driver, the postman, the somebody on the train that could have been with COVID.
yes, Your Lordship, and that is not contended. However, as is outlined in this case, which I will refer to further in my submission, the Vhl Exception, as it has become known, is not restricted to the specific circumstances of this case. Does that answer your question?
No, it doesn't, but please expand upon it. What I want to know in particular is how, not that there are other situations in which this case could be applied, because we could suddenly find that there's, you know, paint with lead or the cladding cases, but would you accept that COVID being a disease that's out there as a pandemic is wider? And so is there a case that you can point to where something that is effectively catchable anywhere is covered by this case?
No, Your Lordship, and not in that respect. However, as I have previously stated, COVID can be caused by a single particle. That is particularly true of the nature of COVID-19. There's also a point to be made, Your Lordship, with regards to the unprecedented times that COVID-19 that we are living in during this pandemic, in that there is likely very few cases in which similar circumstances have arisen. Thank you. This particular issue was the reason why the Vhl Exception was developed. This is highlighted by Lord Roger, which you can find highlighted in green on page 232. To summarize the position, Lord Roger outlines that the purpose of the Vhl Exception is to provide a cause of action in negligence upon using the Vhl test. My apologies, where upon using the Vhl test, the claim would ordinarily fail. This case demonstrates that the alternative test of material increase in risk applies in cases where there are two potential causative factors, one negligent and another non-negligent, and not solely where there's more than one negligent defendant, as was in the case of Vhl. This is summarized by Lord Roger, which you can find highlighted at the bottom of page 201. Further, it was stated by Lord Kay, you can find this passage on page 241 of the bundle, that the alteration to the general test was thought necessary in order to cater for particular difficulties that asbestos-related diseases present. It is submitted that COVID-19 cases pose similar difficulty in established causation on a general rule, and as such, material increase in risk is a sufficient test that may be applied. I may direct the bench's attention to the case of Chester, which you will find on page 250 of the bundle. Would you care for a summary of the facts of this case?
Yes, please.
The claimant, Chester, had managed with bad back pain for several years, which severely limited her ability to walk. Medical examination and test revealed a problem with her spinal cord, and subsequently her doctor suggested that she undergo surgery. However, this surgery carried a minor risk, approximately 1%, that it would in fact worsen the issue. However, the claimant had not been warned of this. The claimant agreed to the operation, which was carried out responsibly. However, she fell within 1%. The claimant subsequently submitted that she may not have consented to the surgery had she been aware of the possible risks. The case of Chester is another example of how the traditional approach to causation may be modified, despite there being no direct English authority enabling the courts to do so. This is highlighted by Lord Stein, which can be found on page 262, highlighted in yellow. Would the bench like the quote read aloud? Furthermore, Lord Stein, I believe at the bottom of the same page, states that this modification is not restricted to the particular facts of the Vhl case. He further states that it would be unrealistic to suppose that the principle will not over time be the subject of incremental and analogical development. He also states that at the very least, the Vhl case shows that where justice and policy demand it, modification of causation principles is not beyond the wit of a modern court. In this case, it was concluded that on policy grounds, a lower threshold test was justifiable. It is submitted that if the court found for the respondent today, justice will have been denied. Businesses, as my learned friend has outlined, already face substantial financial pressure to cut corners in safety measures, particularly relating to COVID-19. This risk is compounded by the likelihood that businesses would then be aware that claims in tort, my apologies, would be aware that claims in tort are more likely to be defeated given the principle today. It is therefore submitted as a lower threshold test, such as material increase in risk, prevents this from happening if it were to be applied. As previously submitted, the lack of the lack of safety measures taken by the respondent, such as the use of face coverings and limiting capacity, materially increased the risk that the appellant would suffer harm. If please at the bench, I will now begin my third submission.
Please.
I will now address legal causation. The final element of causation that must be established relates to the remoteness of the harm suffered and any intervening acts. If I may direct your attention to the case of Haynes and Harwood, which you will find on page 284 of the bundle. Would you give us some of the facts in the case? To summarize the words of Lord Justice Greer, which you will find highlighted in yellow on page 294, where an accident is the natural and probable result of the breach of duty, when it is one of the things that is likely to occur as a result of the wrongful act, it is no defence. It is known that Miss McIntyre did not impose any government guidelines at her theatre. Masks did not have to be worn, and social distancing was not required in the indoor venue that seated 2,200 people. It is submitted that the contraction of COVID-19 can be said to be a probable consequence or one of the things likely to occur as a result of not exercising such safety regulations. It is known that social distancing and mask wearing can significantly decrease the likelihood of contraction of COVID-19, and the use of antibacterial hand gel and sprays effectively eliminate the virus from surfaces. It is therefore clear that it is one of the things that is likely to occur if no such precautions are taken. It is submitted that there were no intervening acts to constitute a break in the chain of causation, as however outlined by Lord Justice Greer, which you will find on page 291 of the bundle. Where harm is suffered as a result of a wrongful act and further act by an intervening person, this does not in itself prevent the court from coming to the conclusion that the accident was the natural and probable result of the breach of duty. Furthermore, it is outlined that there exists no absolute rule that an intervening act by a third party is enough to break the chain of causation. This passage can be found on page 292.
So can you address the elephant in the room? What about the floodgates argument? If we were to go with you, then every single, because Occupiers Liability Act doesn't just apply to commercial premises, you accept that?
Yes.
So every single household which allowed somebody to come in as a visitor and they didn't open the windows and they didn't have masks on and they had X number of people in, if something goes and gets COVID, they'll be sued.
Respectfully, Your Lordship, I believe that a distinction can be drawn between that scenario and the case before the court, in that Mr. Barker is known to have worn a mask at the theatre, to have taken all precautions that he could have to prevent him from contracting COVID-19. Whereas there is an element of assumed responsibility in that, in the given scenario, if one were to attend a house party, for example, they are assuming that there is the potential to contract COVID-19.
Yes, but how's that different to going to the theatre, where you're assuming the potential to contract COVID or to become infected by COVID-19?
That may be so, Your Lordship. However, as my learned friend has stated, contributory negligence, to which I believe you are referring, is not a defence in its entirety. It is a partial defence.
No, what I'm referring to is the floodgates. That where, in principle, is this any different to every single person who went round and sat in somebody's home and didn't have proper ventilation, and everyone else was not wearing masks, and they hadn't asked everyone to have a lateral flow test? How's that different?
Respectfully, Your Lordship, it is different in the fact that a lower threshold test, such as material increase in risk, is still decided on the balance of probabilities. It is admitted that it would not open floodgates beyond a certain amount, as was just and reasonable. Mr. Barker's actions are not, therefore, in themselves actions which broke the chain of causation. The harm is not too remote a consequence of the respondent's actions, and there were no subsequent events to satisfy a break in the chain of causation. Injury was reasonably foreseeable, given the lack of safety precautions taken, and this caused Mr. Barker to suffer harm as a result. Unless I've made clear, this concludes the submissions on behalf of the jury.
Good evening. May it please your lords and ladyship. As opposing counsel stated, my co-counsel and I will be representing the respondent, Ms. Camilla McIntyre. The respondent counsel respectfully requests that the Supreme Court dismisses this appeal and upholds the decision of the Court of First Instance for the following two reasons. I will begin with the first ground of response, which is that going beyond the current government regulations falls outside the reasonable scope of duty owed to audience members, and that the risk taken by the appellant was an obvious one in which they were well aware. My learned junior will then continue with the second ground of response, exhibiting that even if a breach of duty had occurred, there is not a sufficient causal link to establish an action of negligence. If it pleases your lordships, I will now begin my first submission. Thank you. It is submitted that the respondent did owe the appellant a duty of care. However, this was a general duty of care, which does not nor should extend beyond the given government regulations at the time. If I may ask your lordships to direct your attention to the Occupiers Liability Act 1957. Would your lordships care for a description?
No, thank you. We're familiar with that.
Thank you. If I could direct your lordship's attention to page 10 of the respondent bundle. As stated in section 2.2 of the Act, occupiers hold a general duty of care to all lawful visitors to keep them safe within the reasonable expectation. Ms. McIntyre upheld this standard of care by consistently complying with and maintaining government regulations which are legally binding, in comparison with guidelines which in the instant case are purely advisory. If I may ask your lordships to direct your attention to the case of Robinson and Chief Constables of West Yorkshire, located on page 27 of the respondent bundle. Would your lordships care for a summary of the facts?
Please.
Of course. It is submitted that in the case of Robinson, Ms. Robinson suffered injuries when she was knocked over and fallen on by two police officers who were physically apprehending a suspected drug dealer while she was in close physical proximity. Both the trial court and the Court of Appeal held that as police officers, the two were immune from a claim of negligence. However, the Supreme Court held that a duty of care was owed. Police owe a general duty of care under the ordinary rules of negligence as other persons. They owe a duty to avoid causing foreseeable personal injury to other persons. If I could direct your lordship's attention to page 36 of the respondent bundle, specifically paragraph 21. It is here where the case asserts the incremental approach to a duty of care by establishing that the use of caparo as a tripartite test is mistaken. If your lordships could scroll to page 38, paragraph F of the respondent bundle, it is there that Lord Justice Reed emphasizes that it is only when legal principles cannot provide an answer that the law will turn to the characteristic approach of developing the law incrementally and by analogy with established authority. While recognizing COVID-19 is a novel circumstance, the legal principles to a duty of care owed by an occupier in relation to personal injury are established. It is submitted that my learned friend's endeavor of establishing a new duty of care for the reason that the current duty does not extend to the harm suffered by the appellant will not maintain coherence in law, negating the fundamental existence of caparo as an approach.
But isn't this, how do you address the argument that this is akin to an asbestos case? So you can't directly prove, and you could never prove that the virus being picked up at that particular theatre at that particular time, but because of the increased risk that the law needs to step in and do an asbestos type approach.
Thank you for raising this question, Your Worship. It is submitted that although that may be the case, this is a duty established in personal injury of tort and negligence. And although it can never be fundamentally 100% whether the virus is existent within the premises. I apologize, Your Honor. What could you clarify your question?
It's the asbestos argument that you've got a particular, let's for a moment, because let's put the virus to one side. Let's say there's an outbreak of scabies in the country, which is a horrible skin condition that you can pass from person to person. You have to burn everything. Now, if it was at lots of different venues and you've got everybody going in and no one being tested for scabies and all sitting together, etc., would that not be an example of where you could use the asbestos approach, where if there's a significant risk and you're exposing someone to a significant risk, that you don't have to go beyond that to prove causation?
It is submitted, Your Lordship. My submissions are concerned with duty of care. However, my learned junior will focus on the causation aspect of this case, in specific dealing with the asbestos argument. However, from as I am aware, the duty is imposed by law of care. And as regulations state, this is the law that must be abided by all businesses. If Your Lordship is referring to the expected care as referring to guidelines, these are purely advisory and therefore have no legal standing. Ms. McIntyre was following exactly what the basic law required her to do in order to keep patrons safe.
Yes, but then how do you address, does that mean that anyone who, let's take the smoking analogy. So there was a point at which the tobacco industry supposedly knew that smoking was dangerous before the government intervened with regulations, etc. Does that mean, are you saying that no one could bring a claim based upon smoking at a younger age because the regulations haven't changed?
It is submitted that at that time, there may not have been an established duty in the case of smoking in terms of an occupier's liability for smoking on the premises, if this is what Your Lordship is referring to.
Now, what I'm asking you is the same question I asked over here. It's the link between, is it necessary to have a regulation and to comply with the regulation? Does that let you off the hook altogether?
It is submitted by law. This is what is required, is to comply with the regulations. It is not submitted that to comply with guidelines is the legal stance as per the law.
And you're saying that gives you an absolute defense?
In the instant case,
Yes.
So from memory, I'm not aware that there's any regulation or statute that says that you mustn't over polish a staircase. Because they've got a wooden staircase and you wax it so that you go on it and you just slip. Now, if it isn't, are you saying that if it isn't a government regulation or statute saying you mustn't over polish a staircase, that if somebody knowingly over polishes a staircase, knowing the risk to anyone who comes in going up and down that staircase, that they've got an absolute defence because there's no government regulation or statute telling them not to do it?
It would appear that in that circumstance, the contractor who polished the staircase was not being reasonable while completing their task. It is submitted that when businesses and or personal bodies are completing their tasks and their services provided, they must do what is reasonable in the given circumstances. This can be in a compliance with what is regulation. However, it is not reasonable to over polish a staircase, and in that case, they may be found liable.
Okay, so let's take an analysis to the theatre then. Let's say that you know that you sold a ticket to somebody who has a nut allergy. Would it then be reasonable for that theatre to go and hand out packets of nuts to everybody to open up in the theatre, knowing that somebody there with a nut allergy?
Are you suggesting, Your Honor, that Ms. McIntyre was aware of the personal medical circumstances of every patron which entered into the theatre?
No, I'm asking you to address the particular analogy, because the next point to that is if you know there's a pandemic and a disease going around, and you know that everybody is potentially vulnerable to that disease, so everyone potentially has a nut allergy going in there, that you're exposing them to a clear and obvious risk.
It is submitted that at that time, in relation to the present case, Ms. McIntyre is not a professional in any sense in terms of medical care. And although it may have been foreseeable in the given circumstance that COVID may arise, that is not a sufficient cause and negligence to bring an action. Furthermore, she was complying with what was required by government regulation, and it is submitted that government regulations do refer to medical professionals to advise businesses on how to conduct themselves during such an unprecedented time. Therefore, while following what was complicit, she was abiding by the law and doing what was reasonably expected of any business owner at the time. May I ask your lordships to direct your attention to the case of Con and Meadows, located on page 71 of the bundle. Would your lordships care for a summary of the facts?
No, just the please.
It is submitted that the legal principle in Con and Meadows is that a defendant cannot be held liable for harm not within the scope of duty of care. Although this case is under the context of medical negligence, the legal reasoning can be applied to cases of personal injury to define the limits of the scope of duty according to an occupier. On page 93 of the respondent bundle, paragraph G, Lord Hodge and Lord Sales state the necessity of determining the nature of the service provided by the respondent in order to determine the accurate duty imposed by law. The nature of the service undertaken by the theater management was to provide the appellant with a safe entertainment experience, as was reasonable in compliance with the government regulations at the time. If your lordships could then scroll to page 92 of the respondent bundle, paragraph D. Lord Justice Hodge and Sales iterate that despite the consequences of an omission, there will not be an action for liability if the harm falls outside the scope of duty of care. It is submitted that as the risk of harm to the appellant was not a duty of care imposed by law on the respondent, therefore it is not within the scope of duty of care of the theater management. On page 89 of the respondent bundle, paragraph 48, Lord Hodge and Lord Sales then continue to reference the case of Caparo to demonstrate that there are circumstances in which harm can occur, which is completely outside the respondent's duty of care. The Lords continue at the bottom of the page to submit that it is not within the scope of one's duty to take responsibility for all the consequences which may arise due to a service being provided. The respondent cannot be held liable for all the possible consequences, regardless of foreseeability, that the appellant suffered due to their adherence to government regulations. Furthermore, if I could direct your Lordship's attention to page 85 of the bundle, paragraph D. It is once again there where Lord Justice Hodge and Lord Justice Sales refer to the words of Lord Justice Oliver in the case of Sutherland Shire Council and Hayman, that widening the scope of one's duty to include a purpose for which it was not intended would extend the scope beyond its reasonable limits. If I may ask your Lordships to direct your attention to the case of Lewis and Six Continents, located on page 17 of the bundle. Would your Lordships care for a summary of the facts?
No, thank you.
This was an occupier's liability case, which made the significant declaration concerning the unreasonable expectation of an occupier to comply and adhere with a recommendation for best safety practices. If your Lordships could turn to page 22 on paragraph 13 of the respondent's bundle. The quote can be found at the bottom. This is where Lord Justice Ward references the judge of the Court of First Instance, declaring that the duty of an occupier to take care as is reasonable, and in the case of Lewis, the non-compliance with the recommendatory width of a windowsill was not within the scope of the occupier's duty to keep the claimant reasonably safe. On page 23, paragraph 13, Lord Justice Ward continues this point by alluding to the potential onerous expectations that arise from enforcing such guidelines. The burden of such an expectation would have resulted in the theater's cease of operations due to lack of funds, and such a precedent could pose detrimental for any and all businesses unable to comply with
Where's the court approve this? The paragraph 13, they're citing the judge at first instance.
Correct.
Okay, and that's just giving the background. Where does the court approve of what the judge at first instance is saying?
It's submitted that prior to the quotes, the justice is referring to an agreement with.
And take us that sentence.
It should be on, page 22 of the respondent bundle, paragraph 11.
On which part?
I believe it is the bottom of paragraph 11. Yeah.
So he's referring to the statement of principle in paragraph 36 of the judge at first instance, but that's not what you're asking us to rely upon. You've asked us to rely upon paragraph 13, and where does the judge say that he agrees with paragraph 13?
I believe that the judge at first, and the judge in the current case, at the bottom of paragraph 11, states, I interpose by saying that no challenges have been made to the latter statement of principle.
Yes, and he's referring there to paragraph 11.
Correct.
Yes, so you've taken us, however, to paragraph 13, which is described as the nub of the appeal. So where does the judge agree with paragraph 39?
It appears in paragraph 14. It states, now appears for the appellant, and I am grateful to him for his submissions.
That's not, I think that's just the the judge being polite to counsel for the appellant. That's not saying I agree with the submissions or that his submissions are correct. Where does it say that paragraph 13 is right?
It was my interpretation while reading the case, Your Lordship, that while referencing the direct quotes of the judge at first instance, without negating any of what he has said, was that it was in agreement with what was stated. If it pleases Your Lordships, I will now begin my second and final submission. The general rule in occupier's liability is that there is no duty to warn or protect against obvious risks. It is submitted that the risk of attending a live entertainment performance during a global pandemic was an obvious risk in which the appellant was more than reasonably aware. If I may ask Your Lordships to direct your attention to the case of Staples and West Dorset District Council on page 104 of the bundle. At the bottom of page 108 of the respondent bundle, Lord Justice Kennedy states that there is only a duty to warn of potential risks where a visitor would have been unaware of the nature and extent of the risk had there not been a warning. Your ladyships, or your lords and ladyships, unless I can aid the court further, this concludes the submissions on behalf of the lead respondent.
Any questions? Thank you.
Good evening, your lords and ladyship. If it pleases the court, I will begin the first submission on behalf of the junior respondent in regards to the second ground of the appeal and arguing that the learned judge and court of appeal were correct in their finding that causation could be or could not be established to ground an action in negligence. There is no causal link between Ms. McIntyre and Mr. Barker since she did not materially increase the risk of harm sufficient to assume causation. When determining if a defendant's breach has caused harm to a claimant, factual causation and legal causation must be established together. As my co-counsel has stated, there must be an established duty which has been breached to ground such a claim, which the present circumstances do not appear to extend such a duty to go beyond what has been required by the regulations which were adhered to by the theater management. The appellant alleges that the duty of care owed to him and the theater guests is one that should go beyond the government regulations in place at that time, and thus attribute causation to the respondent, Ms. McIntyre. The case authority from the House of Lords of Fairchild and Glenhaven Funeral Services Limited from 2003 was distinguished by the court of first instance. On this issue, and for good reason, would your lordships and ladyship care for a summary of the facts of this case? This case's focus was on the wrongful exposure of asbestos to employees at several different employments, is of particular importance under two grounds: that a breach of duty to the appellants and the nature of asbestos and its causal relationship to the onset of mesothelioma. On the first ground, may I turn your lordships and ladyship's attention to the page of 122 of the respondent's bundle, paragraph 3 at section A. Here, Lord Bingham outlines the admitted breach of duty in the failure to provide safe working conditions for employees as laid out in section 3 of the Factories Act 1961. For the instant case, the contents of this act are not important, but what is that this statute outlines the scope of an employer's duty to their employees. The inability to keep them reasonably safe via the wrongful exposure to substantial amounts of asbestos during manufacturing processes is the negligent action which caused material harm. In the instant case, it cannot be said that a negligent action occurred in terms of a harm, in terms of violation of a statute. Government regulations of the time had been adhered to, thus limiting the scope of the occupier's liability and the occupier's duty, as my co-counsel has previously stated, as stated on page 128 of the bundle at paragraph 15 at section H. The duty is doubly incumbent on an employer to safeguard against additional risks to their employees, a relationship which is decidedly different to that of theater goers and theater management. The second ground of the Fairchild pertaining to the nature of asbestos and the consequence of exposure is relevant because of the differences to the COVID-19 virus. Mesothelioma is not a common affliction, typically only found in 1 in every 1 million people, but those subjected to occupational exposure are 1,000 times higher on average to develop tumors of this kind, which is noted on page 124 of the bundle at paragraph 7, section B.
So what was that statistic again?
The citation or the?
No, the numbers who, if they're exposed, would.
The numbers typically expose 1 in every 1 million of the general population, but the increase of that risk after occupational hazard had been introduced was 1,000 times higher than this. A number that is far higher than the alleged statistics as presented by our learned friends.
Okay, so how does that compare to the risk of contracting COVID if you've been exposed to the COVID virus?
Well, the main difference that should be considered in this instance is that asbestos is specifically linked to locations, particularly the manufacturing processes as seen in Fairchild's case. Now, why this is important is because while this is limited specifically to the employer's liability in these cases based on the Factories Act 1961 statute, section 3, it is materially different because the exposure and occupational hazard would only be found in those factory locations and settings, which the wrongful exposure was found to increase such chances.
But as of October 2021, did we not already know, as clearly established, that exposure to COVID or the risk of contracting COVID was exponentially higher in areas of close social contact and large social gatherings?
That is correct, that is well known and well established by the time of October 1st of 2021. The important distinction between the Fairchild case and this fact in regards to COVID's transmissibility being that it is caused between people rather than by a factory process where asbestos would be emitted into the atmosphere, is that the risks associated with COVID are part of everyday life at this point of October 1st, 2021. The risk of contracting COVID could occur at any location, at any time, between anyone, based on any minor social interaction, as the doctors in the case noted was possible. The reason for this difference and the reason for this distinction being, it cannot be assumed that material increase of risk in the instant case in Ms. McIntyre's premises can be specifically attributed to the spread of COVID-19, given that the risk of COVID-19 was present anywhere at any point between any social interaction, as the doctors had noted. The travel between the theater while spending time at the theater and the travel from the theater could have just have as likely been subject to the risks of contracting COVID-19.
Okay, let's break that down. First of all, on your distinction of asbestos being a factory process or something within the building.
Occupational hazard, yes.
But there are many instances in which, let's say at the moment, bird flu. So all poultry have got to be, all domestic poultry has to be locked up at the moment. It can't be allowed to roam free. That's why none of us are getting free range eggs as of this week, because they've all been locked up for so long. So you've got there an instance of a spread of disease, but it's not a factory-based spread, is it?
That is correct. And the reason that would be important is because the case for asbestos is specifically related to that of factories. Whereas an avian flu, for example, while it could be spread anywhere, similar to COVID, there have been precautions taken against it as per government regulation and insight. In this case, government regulation had been adhered to as per the theater management of under Miss McIntyre.
Yeah, but the distinction you were making as I understood it, was you've got asbestos and you've got a function, and that somehow that was different to a disease. So if, for instance, the government regulations had still been in place, banning mass gatherings, and Macintosh had opened up the theatre, do you say there would have been a private claim then if she was doing so in breach of government regulations?
In breach of government regulations, that could very clearly be a private claim, but it could also be a public claim.
Yeah, but let's put that to one side. But you would agree that if she had breached government regulations, then the claim could arise.
If they were to breach those government regulations, indeed. In the instant case, they did not.
Okay, so then we want the second question, which is the fact that there are no government regulations in place an absolute defence to this? Or are there, under the common law duty of care, is there not an obligation outside of government regulation statute?
Under the common law duty of care, it should not be held, in this instance it is submitted, that it should take precedence over government statute and regulation at this point in time, given on these circumstances. The distinction that it is submitted is made here, specifically between asbestos being that of primarily an occupational hazard, which is limited to those locations, and the wrongful exposure by employers which fail to take safety regulations which are provided by statute and must be taken. With the instant case of COVID, however, since it cannot be narrowed down to a single location or a single process where it is increased risk, that would be the distinction that is submitted by the junior respondent this time.
So you are submitting that she took the government precautions and therefore that's an absolute defence in this case?
Not in the sense that it is an absolute defense, but in the sense that it is not, you are not able to submit or not able to find that material increase in risk to be comparable with causation in this sense, given that she did not increase the risk in herself. With the earlier analogy of handing peanuts out to all of the guests in attendance at a theater, that would be effectively increasing the material risk of harm by the actions of the theater owners in that instance. Whereas in this instance, they did not materially increase the risk and harm, merely they did not prevent against further increase of risk and harm, which will be considered in the second submission of the junior respondent.
So they told everyone not to wear masks.
There was at no point where they told everyone never to wear masks. It was only that it was not required.
Okay, please move on.
Very well. Now, given that urban centers naturally increase the risk of COVID since it is spread between individuals and their interactions, Mr. Barker, traveling into London from an undisclosed location and taking public transportation to and from that theater in question, is alleging that his contraction must have been caused by the relaxation of guidelines at the premises, which the doctors decidedly were unable to hold either situation as more probable for contraction to occur. Assuming that the damage had been caused by the theater management would be to conflate increase of risk in all interactions at the time with factual causation. I ask your lordships and ladyship to turn and direct your attention to the case of Chester and Afshar at page 222 of the bundle, specifically paragraph 61. Would you care for a summary of the facts?
No, thank you.
Very well. Here, Lord Hope highlights the risk inherent in an act, in this case being a spinal operation, that a failure to warn cannot increase the risk of injury. The failure to warn leading to a finding in negligence of a duty to obtain informed consent will be addressed further in the second submission as well. But this does not take away that there were risks that are inherent, and risks, when risks eventuate in that harm, the risk is not necessarily increased. Here, however, it is submitted that COVID infection can occur at random, and failure to follow further guidelines not required by law cannot be the definite cause for Mr. Barker's contraction, for the case of Wiltshire and Essex Area Health Authority. Will your lordships and ladyship care for a summary of those facts?
No, thank you.
Where this case sees a claimant's blindness possibly being attributed to a negligent act by doctors, medical experts identified that various other conditions that the claimant suffered from could have equally caused the claimant's blindness, but none of the conditions or the excess of oxygen which was administered by doctors were found to be more probable a cause than the other, as seen on page 243 of the bundle at F through H, and at page 244 at B through C. When other potential causes cannot be positively identified, causation cannot be assumed. But for Mr. Barker's attendance at the theater, it is not definitely known whether he would have contracted COVID, since he was not just as likely to contract it on his way to and from the theater, and in any social interaction that he might have had on the 1st of October, 2021. Enforcing those further guidelines, on top of the regulations adhered to, cannot positively be identified as a material contribution to the risk, since the risk of contraction is inherent in any and every interaction. And Ms. McIntyre did not actively increase said risks by only adhering to government regulation. If it pleases your lordships and ladyship, I will now begin the second submission on behalf of the junior respondent. The lack of notice of relaxation of guidelines is not required, nor did it impact Mr. Barker's decision to attend the venue. Although notice had not been provided indicating that theater management had relaxed further guidelines, Mr. Barker proceeded to attend the show regardless of his concerns surrounding COVID. As mentioned by my co-counsel, he did not make any attempt to mitigate his losses by requesting a transferable ticket or any other options for that matter. He simply sat and stayed. Chester and Afshar is a case involving medical negligence, specifically on the grounds of a patient not being properly informed of a risk which eventuated and was found to be a negligent act by the defendant. If your lordships and ladyships will look to
hear that, because this isn't a patient case anyway.
And that is particularly the distinction that I wish to submit today, that the owner's relationship between a patient and a doctor, in this case, finding that the omission of a fact leading to a cause in negligence should not be equated between these two cases, given the lack of owner's relationship. So as to the omission to enforce the guidelines, my co-counsel has made reference to the case of Robinson and Chief Constable of West Yorkshire Police on the issue of providing benefits as generally being voluntarily undertaken rather than imposed by a common law. Would your lordships and ladyship care for a summary of the facts?
No, what I would like to know is what's your weakest position? Where is your opponent's strongest point that we need to be concerned with?
In this situation, it would appear that their most important aspect of their submissions would be particularly on the idea that it would require further extension of the scope of the law in terms of lowering the threshold for finding causation. In fact, that is to attribute material increase in risk to Ms. McIntyre, which had been addressed in my first submission.
And so how would the material circumstances have to have changed to give their client a claim?
The circumstances would have had to change in a sense of exactly what was suggested by your lordship, respectfully, that they would have to tell people not to wear masks, for example, or not to take precautions such as social distancing or whatever else. In this case, they did no such thing. They respected the autonomy of the guests at any given moment, by not enforcing further guidelines onto their conduct, which is also a factor of medical considerations in the case of that was seen in Chester and Afshar. The importance of informed consent for surgical patients in that instance is, one, to ensure that the patients are not being submitted to any risks which they're not comfortable in undertaking and accepting, and two, to respect their personal autonomy over their own bodies. In the instant case, we never saw Mr. Barker at any point decide to opt out and withdraw his consent for risks which he was uncomfortable with taking. While he may have paid particular attention and given concern to the risks which were in place, given the venue conditions at that point, At no point did he object to this by leaving or requesting a transferable ticket or taking any measures to mitigate their losses for a non-refundable ticket. Instead, they decided to sit in the theater and attend the show in its entirety. Further, respect for the autonomy of the individuals by not requiring guidelines upon them which dictated their conduct at any given moment throughout their time attending the show. As Lord Bridge states on the last page of 254 of the bundle at B, the law requires proof of fault causing damage as the basis of liability in tort, and that it would be a disservice to society to make forensic processes more unpredictable to accommodate the urgent needs of hard cases. The law should not be changed, nor the approach to determining causation, just because the instant case presents novel circumstances which have not been seen with the likes of a global pandemic. When global circumstances vary, the law must remain a constant and coherent body. Unless I can aid the court further, this concludes the submissions on behalf of the respondents.
Thank you.
Thank you. Thank you.
By 3 minutes, if you'd like to take a moment outside to discuss whether that's that, I can come back to you.
Your Lords and Ladyships, we would like to submit one brief rebuttal in response to the responding council's submissions. In reference to the lead respondent's submission that contraction of COVID as personal injury was outside of the scope of duty of Miss McIntyre acting as the owner and manager of the theatre, it would like to be submitted that previously in their argument they've used sections from the Occupiers Liability Act. Now, unless the responding council would like to pick and choose which sections of the Occupiers Liability Act they would like to apply to this case, this means that the section 2.2 duty should still apply, showing that the duty of the occupier in Miss McIntyre is to reasonably protect the guests to the theatre against risks that may incur in their legal visitation there. Especially in October 2021, one of these risks is clearly the risk of COVID. And so this council would like to rebut the fact that contraction of COVID is in fact well within the scope of the duty of Miss McIntyre as the occupier. Thank you very much. All right. Okay. All rise.
I'll announce the decision on which side we would have decided in favour of, and then you'll
I will
announce the
do,
winner?
yeah, I'll do the thumb up.
Okay, so surprise, surprise, we find for the respondents, and the appeal is dismissed. Now we're with the fun bit, and then we'll give you some feedback.
So we have 4 envelopes, 2 winners and 2 runners-up. Shall I come round there and do that? You were all absolutely brilliant. We were very impressed, all of you. But our 2 winners are going to be, yes, we've forgotten your names in walking around. Olivia, well done, and Kyle.
So I'm going to do some of the feedback. Overall, the standard was very good, but you don't learn anything from me telling you what you all did really well. So no apologies for the fact that I'm going to be telling you some of the things that I would have changed more than how it went. The one bit I didn't like were your skeleton arguments. Now, I appreciate that because this is an exercise, you're told to do about 3 pages of a skeleton argument. But in real life, though the courts want a skeleton argument to be short and pithy, and I'll confess now, I've never been able to write a proper skeleton argument in my life. My skeleton arguments are always written submissions squashed into 20 pages. You're not allowed to go above 20 pages. But a skeleton is meant to make the points. So all of your skeletons read more like grounds of appeal rather than actually directing me to your killer paragraphs. And even if you don't actually cite it, but rather than just having it highlighted, if you say, this is the principle, the tripartite, etc., go to this bit and this bit. So skeletons do need work, but I don't know whether you're going to go to the bar or solicitors, but that's something which will be shared to you later. In terms of the advocacy, something that was common to all of you, but not Olivia, was a little bit too much reading. Okay. Now, this has been live streamed, so I hope it's not being recorded while I confess this and I don't get into huge trouble. But I very, very rarely ever write a.
We're going to just turn it off so you may speak.
Sorry.